I managed every aspect of their lives: school schedules, homework, meals, doctor visits, playdates, and emotional support. Sarah's engagement with them dwindled to perfunctory interactions. She was often distracted, on her phone, or simply absent. For instance, Lily had a leading role in her school play, an event we had marked on the calendar for months. 2 days before, Sarah announced she had an unavoidable work commitment that evening. The Pi later confirmed she was having dinner with David. I recorded her absence, along with Lily's quiet disappointment. There were numerous such instances, each one a painful piece of evidence, not just for legal purposes, but of her escalating detachment from her family. The emotional toll on me was immense. Maintaining a calm, composed exterior for the children and a neutral, considering facade for Sarah, while internally processing the daily reports from the Pi and managing my own grief and anger, was draining. Sleep was minimal, and stress was a constant companion. The decision to file for divorce was made in consultation with my lawyer after nearly 5 months of this. We had a substantial body of evidence, detailed timelines, photographic and video evidence from the Pi, financial records showing her spending on David, including cash withdrawals before her outings and charges for gifts and meals I could tie to their meetings, and my own exhaustive log of her parental absenteeism versus my full-time caregiving. My lawyer was confident we had a very strong case, not just for divorce on grounds of adultery, but for securing primary custody and arguing against significant spousal support due to her conduct. The logistics of filing were carefully planned. I secured a new lease on a house in the same school district to minimize disruption for Lily and Tom. On the day of filing, while Sarah was out, reportedly at a yoga workshop, which the Pi confirmed was an afternoon at David's, I moved the children and our essential belongings to the new residence. Sarah was served with divorce papers and a motion for temporary primary custody that evening upon her return to a nearly empty house. Her reaction, as relayed to me later through legal channels: I initiated a strict no direct contact policy, with all communication to go through lawyers or a court-mandated co-parenting app for child-related logistics only, was one of utter shock, followed by intense anger and accusations of betrayal. She had genuinely believed I was slowly coming to terms with her vision of an open marriage. The revelation that my consideration had been a calculated strategy to gather evidence against her was, by all accounts, a devastating blow to her narrative. The divorce proceedings were contested, though not as protracted as they might have been, thanks to the sheer weight of our evidence. Sarah, through her legal counsel, initially pushed back hard. She sought joint physical and legal custody, significant spousal support citing her years as a stay-at-home mother, and a larger share of the marital assets. Her lawyer attempted to discredit the Pi's evidence as an invasion of privacy and painted me as vindictive. We had several hearings before a judge. My lawyer presented our case. The Pi's testimony, supported by his detailed reports and visual evidence, was compelling and irrefutable.